Colleagues, good morning. Welcome to our lecture on the statistical measurement of corruption developed and recommended by the UNODC to be used by the member states. My name is Azat Jolbasevich. I'm the National Coordinator of the Anti-Corruption Program of the Regional UNODC Office in Afghanistan, Iran, and Central Asia and Pakistan. The webinars are held on the basis of the Central Asia platform for the fast tracking of the UNCAC. Today, we are moving to the review of the number of questions related to the measurement and assessment of the preventive anti-corruption measures, in particular, the personnel, staffing in the public sector, integrity of the independence of the judicial system, and the conflict of interest. Today, we have here our experts working with us within the webinars. We have the expert from the UNODC and also the head of the Information Analytical Center of the Regional Office, Ms. Salome Flores Sierra. And traditionally, we can start with the practical questions you have. And I would like to address the first question to Mr. Stolpe. What, in your opinion, and actually we will have 3 questions considered today. They are quite complicated and comprehensive, but first of all, we would like to speak about the practical aspects, how the practice works. And also with regards to the recruitment of the civil servants based on merits, what will be the most efficient practical tool which you have observed in various practices, and what are the elements who are working better? Please share your experience in this matter.
Good morning, colleagues. Good morning, Azat. Thank you very much. Very glad to see that today we have an increasing number of colleagues joining us for this regular webinar. And of course, as in previous occasions, I want to really invite you to give us your feedback, to share some ideas of topics that you would like us to cover so that we are developing this series of webinars further and make it more relevant to your specific work. Now, Azat, of course, today, aligned with our discussion so far, we're going to be zooming in on some of the critical provisions of the UN Convention Against Corruption in its prevention chapter. And one of them is obviously the merit-based hiring of public officers, and in general, how to sustain and promote integrity, accountability, and transparency in the public sector. And it's needless to say that in order to achieve that, obviously, the very first step is that at the very entrance to that public sector, we need to make sure that the doors are created in a way that they uphold these principles of integrity, accountability, and transparency, which de facto is merit-based hiring. Now, why that is so important may be self-evident to most, certainly the colleagues here in the webinar. But nevertheless, I wanted to really mention it because I've seen in some other countries that I've worked in of how this conditions essentially the entire civil service, and it essentially undermines the civil service in its roots. And that is nepotism and, of course, also outright bribery, corruption at the entrance point into the civil service. And de facto, you have to be very clear that if candidates, students coming from university, for example, have either to resort to connections, whether it's along ethnic or family lines, or even to bribery, as it is unfortunately the case in some countries, in order to be hired into the public sector, I think it is relatively clear of how they will be behaving themselves in that public sector once they have become themselves civil servants. So probably more than any other area of prevention, this should really deserve a lot of attention. And we need really to make sure that at all stages of the hiring process, we put in place the necessary measures to prevent the opportunities for corruption really to play out in the favor of individual candidates. And there's, of course, a lot of general measures that I don't think we want to go into now in terms of the technical details, making sure that the vacancy announcements are specific so that you can really test actually the CVs against the individual applicants, that you make sure that you have proper testing, that, for example, when you have written tests, that those are handled anonymously and ranked by those that are rating those tests, that you make sure that the questions in those tests are not known inside the public service widely so they cannot be leaked to candidates, that you make sure that your interviews at a later stage are done by diverse panels from different parts of the administration, so you reduce the chances essentially of anyone influencing the outcomes of those interviews unduly, and so many more technical measures that I think are probably well known to most of our colleagues that are joining us today.
Thank you so much, Mr. Stolpe. But this is not the only question I actually wanted to raise, because to some extent, the recruitment of the civil servants is also related to the independence of the judiciary as a system, and also the conflict of interest prevention mechanisms. So maybe we could try out to find the general answer to the question. For example, what are the key conditions which promote the independence of the judiciary system in decision making, and how it is connected to the conflict of interest prevention mechanisms and also conflict of interest management?
Okay, two very different questions, I think. Now, on the conflict of interest, I just want to mention essentially one thing, in particular, as we're seeing many of the countries, including, of course, the one from which I'm speaking to you, meaning Uzbekistan, have introduced conflict of interest rules or even legislation in their respective legal systems, I think, which is very laudable. They have given an definition of what constitutes a conflict of interest. They have also, in many cases, highlighted the issue that a conflict of interest is not only to be judged whether it actually is a conflict of interest, but also to avoid the appearance of a conflict of interest. But all of that is only really working beyond essentially giving civil servants an initial idea of what it constitutes a conflict of interest and how to avoid it. The other side of the coin, and that is missing in many countries, is actually a functioning system through which public officials are required to declare their assets and interests. Now, in this case, I can tell you what applies to myself, because I'm part of a system that requires me to declare on an annual basis, actually, all my assets and my interests and the evolution of those assets and interests, as I have, certain decision-making functions with regard to the management of human and financial resources in the UN organization itself at the regional level. And it's very detailed. It is reviewed with great scrutiny. And what I find most interesting is, while actually the issue of assets comparatively plays a much smaller role than what I had imagined, because because I haven't been enriching myself in any way, but more importantly, because that is not really where actually the bulk of the issues arise for your average public officer. The bulk of issues arise actually in a situation when your private interests or the private interests of people that you're connected to in one way or the other are starting to interfere with your official functions. And that is reviewed in our own system with massive scrutiny. And that is why you need the system. And the fact that we do not have that system in many regards basically means that our conflict of interest regime is limping, because we're essentially hopping around for the time being on one leg. And I hope that this shortcoming will very soon be addressed. Certainly here in Uzbekistan, there's some clear instructions by Mr. President to fix this gap in the legislation. But I would certainly also strongly recommend for all the countries that have conflict of interest legislation established to make sure that also it is accompanied by an asset and income declaration system. Yes, and of course, then on judicial integrity. Well, this is really, really important, because we need to understand where this is actually coming from. When the Convention Against Corruption was first conceptualized, we are talking essentially sort of the years 1999, 2000, 2001, when the initial idea was born, and then there were conversations that started among member states what should actually be part of such a convention. And at that time, there was grave concern, essentially, that the very system that was supposed to enforce a very large part of this anti-corruption legislation, in particular the criminal part of that anti-corruption legislation, was actually itself undermined to a large extent by corruption widespread, both among prosecutors as well as among judges. Now that gave birth to this specific article, Article 11 in the UN Convention Against Corruption, that is specifically requiring member states to take up measures that are effective in promoting integrity among those two professional groups and preventing occurrences of corruption. And just to give you an idea of how important this is, there's a country that I've been doing quite a bit of work in East Africa, where there was a popular saying of, why should I hire a lawyer when I can buy a judge? And if that is sort of like the baseline from which we are starting to work from, then we understand, of course, very evidently of how important it is that we are first taking a step at preventing essentially the occurrences of corruption in those critical institutions that were often also basically determining as the guards. So there's also the question of who's guarding the guards. And that has led us, especially in UNODC, to develop a whole range of programs and projects on strengthening judicial integrity and capacity in a number of countries, ranging from South Africa over Moldova, over Nigeria, of course, Kenya, we had some work, Sri Lanka, I'm probably, Indonesia, of course, and I'm missing a couple of others probably off the top of my head. And the interesting thing was really that in a relative foreseeable time, meaning in the course of even 5 to 10 years, actually, in some of those institutions, it was possible to make some really considerable progress. And we have developed a whole range of very interesting tools, which by now also do exist in Russian. And the one that I think I would really like to bring to your attention is an e-learning program of 3 sessions, 1 hour each. And those sessions, and it's also comes with a final test that gives you a certificate. And that really gives judges sort of like a full range of knowledge of the rules and regulations that are governing universally the conduct of judges, is based on the so-called Bangalore principles of judicial conduct, which have been developed by judges for judges as guidelines of which are the values of judicial conduct, as well as the specific rules of behavior. And that training really gives you, through a whole range of practical exercises and knowledge products, a very solid understanding of what is expected from you. And I would really like to encourage everyone that is not yet familiar with this tool to maybe take a look at it. Maybe we can share in the chat later a direct link. And to also encourage, of course, in particular, the judicial and prosecutorial profession in undergoing this training. And actually, in a couple of countries, the judiciaries, especially the high councils of judges, went as far to actually make it mandatory for all judges to conduct this training, which is also very helpful later when you're looking at accusations of ethical violations, because when people have been trained, it is much easier to hold them to account to the rules of conduct.
Thank you so much, Mr. Solpe, for this comprehensive answer. Indeed, there are a lot of things which could be followed in terms of the proper organization of the activities, but still we need to be able to maintain the functioning of the well-established system, and it will meet the international standards. So this is an ongoing work. It's a not one-time thing. So that is why regularly we need to have an assessment in terms of the compliance with the international standards. And actually, this is the purpose for the framework, statistical framework for the measurement of corruption, which we are looking at through the series of our webinars. And I would like to remind everyone, our dear colleagues, once again, that this is a regional event which is organized within the regional platform. We are joined by the colleagues from the entire region, and moreover, our lectures and presentations, they are uploaded to our YouTube channel, and they are available to a vast majority of the possible participants who are interested in the methodology on how to combat corruption. Today, we will continue our joint work. We are more than happy that we have more and more participants joining us, and hopefully we will follow the same trend. And please, dear participants, do share the link to our webinars with your colleagues and friends. Maybe you know those who are doing the research, or maybe there are students who would be interested in studying the ways of measuring the corruption. Now we can move to the main part of the webinar. I would like to hand over to Ms. Salome. So we would speak about the methodology further on how to measure the recruitment process, how to assess these practices in the judicial system, and also how to manage the conflict of interest. Ms. Salome, over to you.
Thank you very much, Asad. I think you can hear me now. Good morning, dear participants. Very glad to have, like my colleagues were saying, more participants joining us in these sessions, and very grateful to Mr. Stolpe for setting up the stage and providing this context of the measurement of the topics to date, public hiring based on merit, independence and integrity in the judiciary, and conflict of interest. Just if we can continue to the next slide, please. Just for you to remember, the UNODC Statistical Framework covers three main aspects that are in line with the UNCAC, with the UN Convention Against Corruption. In the previous webinars, we review all those indicators that are connected to areas that are criminalized under UNCAC or are recommended to criminalized following UNCAC. And then today we are starting with the second dimension of topics. These are preventive measures, as you can see from this slide. And then we will have a third dimension later on regarding the environment to report and address corruption. So the indicators today that we will review today, and for those that are joining us for the first time, are part of this framework that was developed by UNODC following consultations with member states in all regions. More than 80 countries provided feedback. The sets of indicators included in this framework are the ones that member states suggested, and some of them already have data to populate these indicators. And for those that do not have or do not monitor these indicators regularly, we recommend you to review the statistical framework, familiarize with the suggested indicators, and if we can move to the next slide, please, and think about which indicators are more relevant and are a priority for you in different countries to monitor. The framework is just kind of a menu for countries to choose which areas are more important for them to monitor. We do not intend to have all countries collecting all this massive amount of data, but rather to see which indicators can help them to understand the trends and the patterns of corruption, to monitor them over time, to have a better understanding of the magnitude of the problem, of the risk sectors, and based on this data, to think about targeted interventions. So just a few words before we actually dive into the indicators. We can move on to the next one. And in this one, basically, I think Oliver already mentioned the importance of measuring this area following Article 7, which basically focus on different aspects of public sector, but I think the stronger focus is on recruitment, because of course the recruitment is the filter, let's say, to ensure that the recruitment of public officials is based on clear criteria, clear and consistent criteria, transparent criteria that allows for the selection of those that are more qualified and capable to actually hold that position in the public sector, and to make sure that those that are recruited because of their merits and not because of their connections. And only through the recruitment of those that are more suitable for the position, the public sector can become more efficient and more professional. So this is basically the rationale behind monitoring this area on the preventive measure. If we can move on to the next one. So for this topic, we have 9 indicators. As you can see, this is one of these topics in this statistical framework, which actually covers all types of indicators. We have indicators that are direct or that directly measure specific aspects. We, countries decided to include an indicator on perception. Then we have indicators that are under the risk, and then under the response. So I think we can move forward very quickly to try to cover all of them. Thank you. So the first one is to understand open recruitment. So this is the proportion of employees that were appointed without an open and competitive recruitment process in the last 12 months. And the suggestion is to have disaggregation at least by sex. So you can see the formula there. Basically, the idea is to divide the number of positions that were openly advertised, divided by the total of positions that were filled, multiplied by 100, so we can get the proportion. And for this, and I see a question in the chat about sharing the PowerPoints in English as well. We can share them. Of course, we have them as well available in English. And actually, I think we will post them on our website later on in both languages. So they are available for consultation for those that are interested. So in this one, in the slide, you can see the requirements usually, and I think I won't repeat this through the whole set of indicators under this topic, because for most of these indicators, we need robust human resources databases, especially on the recruitment process. So all this information is surely available in somewhere in human resources, but most of the times is not prepared in a way that you can actually produce these indicators, but should be somewhere. The issue with getting this information is that sometimes the records or the way that institutions are recording this information is different from one institution to the other. Sometimes also the procedures for recruitment are not the same from one institution to another. And even, these recruitment processes, even if they are in place, they might not be properly documented. So the challenge here is basically to work on good information systems, good recording systems of all these procedures. And of course, there's also the choice for public organizations to have this information and to monitor this information or this indicator specifically internally, just for monitoring purposes, to understand what is the proportion of employees that are being recruited without an open and competitive process. But of course, the recommendation is to not only be able to track this indicator, but also to actually publish this information somewhere, because having this information openly really shows a commitment to promote public hiring based on merit, and really allows everybody outside the public sector to appreciate the efforts by the public sector to monitor and ensure that the recruitment is based on merit. So this is the first indicator. We can move on to the next one. This indicator is about the perception. And like other indicators before in other topics, this indicator should come from a survey. The indicator is about those officials that perceive that the recruitment in their own institutions, it's influenced by the connections that the people that are being recruited have with other officials. So for this one, we would need to conduct a survey in the public sector to understand what is the perception of those already recruited about the recruitment process. So basically, this is the way we come up with this indicator is by having the number of officials that consider that a recruitment was made after personal connections, divided by the total number of officials that were interviewed or that answered a survey, multiplied by 100. And by using this formula, we should get an idea of what is the percentage of public officials that actually think that the recruitment is based on personal connections. Not many countries conduct surveys on corruption within the public sector, but there are some examples in which the institutions actually go and ask their own officials about corruption in general. This is one example. This is just about the recruitment. But of course, the questionnaires that we've seen in countries that are applying such surveys are more comprehensive and cover different aspects. This is just one of them. And of course, there are many considerations for conducting these surveys. Although I have to say, in my experience, I actually helped to conduct a survey like this one in my home country, that is Mexico, specifically in the customs service. And it was interesting because we didn't face any challenges in terms of getting the public officials answering, because basically everybody was asked to answer. But of course, there were some considerations about the subjectivity of the answers, or the caution that some of the officials had when answering. I mean, there were some questions there, but the findings were interesting. Most of them answered. The response rate was very high, and of course, it was also relatively easy to do because we did it online. We didn't, of course, do the interviews because that's not only more expensive, but also more difficult for getting real answers. I think the key was to have the surveys conducted anonymously. And in a way, this help us to get better information. So these are relatively easy and can be informative, but this is one of these indicators that there's always have a high level of subjectivity because it's perception. It's not necessarily that we have facts. And as we have seen from other topics, usually perception on corruption is higher than the actual number of cases, for example, of bribery. So, I mean, this is just, we need to be cautious about the perception indicators because they're not always necessarily reflecting reality. And of course, they can be influenced, like we have seen by specific scandals, for example, or changes or cases that are high profile, and that can have an impact on the perception. Now, we move on to the next indicators. These are indirect measures. We call them indirect measures that actually monitor risks. And if you remember, we have two types of risks, or two types of indicators on the risks. We have indicators that actually measure the opportunities to corruption disease. We try to monitor areas that are maybe enabling corruption or enabling specific aspects. In this case, the indicator is about measuring non-competitive recruitment. And the way we are suggesting to measure this is by getting the proportion of open recruitments that had just one candidate. So this shows that it was not really a competitive recruitment. So we get this by dividing the total number of openly advertised positions with one candidate, or that were selected with one candidate only, divided by the total number of openly advertised positions multiplied by 100. Again, for getting these indicators, we need good human resources records, but there is an additional challenge here, especially, well, in every area really, but for these ones, and we actually face these kind of problems in the UN sometimes, which is when we are trying to hire someone in a very specialized position, the selection process is very complicated and might not be as competitive because of this high level of specialization. So these are some complexities for those in those cases in which it's very hard to select. But again, this is about looking at the big picture. It's not looking at single cases, but rather to have an overview of whether or not selecting or having positions with just one candidate as an applicant and then as the person selected is a trend, if it happens regularly. If we only get one candidate and that is the candidate that is recruited, then that is a red flag, and that may signal that maybe the recruitment process has some challenges that should be addressed, because this is not, it should not be the normal practice. We can move on to the next one. And in this one, this is basically a binary indicator, is yes or no. Again, it's connected to the risks. And in this one, we are moving into the constraints. So this is measures in place that are aiming to stop this kind of corruption, let's say, of this kind of risk in this case. So the indicator is basically understanding the existence of a complaint mechanisms for rejected candidates. If there is this, yeah, how can I put it? Like a window, like, yeah, like a process in place for the candidates that perhaps are qualified and they show it, but were not selected, and they would want to have clarification about why or how was the person recruited selected, and how other highly qualified candidates were not rejected. So again, this is to understand if there is a good human resources policy and procedure to understand what was the criteria and the procedure to reject some candidates and select the most qualified and professional person to hold this position. So very challenging, but again, I think in the UN we do have, or we try to have this kind of systems in place to actually understand how recruitment works in many areas indeed. I mean, in terms of who are the ones that actually make it to an exam, who are the ones that actually make it to an interview, and then what were the markers to actually select a candidate. But this is just to, get from institutions if there is this mechanism in place for those rejected candidates to get back to the institution and understand why they were rejected. We can move on to the next indicator, and this is about the positions that were vulnerable to corruption. And we actually saw a similar indicator in a previous topic, but in this one is basically the positions that are vulnerable to corruption, but connected to recruitment. So the idea is to understand the proportion of vulnerable positions, number of recruitment of these positions vulnerable to corruption that follow risk assessment criteria in the last 12 months. This is extremely difficult because not all public sectors have actually risk assessments in place, or even more so, not all the public sectors have mapped which positions are considered as vulnerable to corruption. So there are many requirements for this indicator, but of course, the recommendation of this framework is ideally to be able to monitor how the recruitment of these positions vulnerable to recruitment to corruption is working. Yeah, and this could be a good indication of measures in place to actually try to deter corruption from happening in these corruptions that are in these positions that are under higher risk of corruption. And I think with this, I will hand over to my colleague Assad to move on with the indicators on the jury. Over to you, Assad.
Please turn off your mics. Some mics are on. So you have already heard earlier about the possible situations when we cannot find the best candidate, the needed candidate. This is one of the requirements of the UNCAC when we try to select people according to the functions which would be performed. And very often we face a situation when the functions required for a certain job are quite complicated, and it's difficult to find this highly specialized professional. But this is the principle to form the professional public service where real professionals perform their duties, and those who are capable to address this complicated tasks. This is the indicator B16, and all of the requirements, as you know, we follow the legislation. So 1.6, here we need to focus on a series of the key questions. Many of these questions, I guess, should be raised in the process of amending the legislation and introducing the mechanisms for the recruitment practices in the public service. But we will speak about the key metrics. First of all, we need to start with the types of the regulatory acts which actually regulate the recruitment process. And it may seem that there is a simple answer to this question, but we understand that apart from the legislation, there are other regulatory documents in the agencies, in the institutions, which should be followed by the employees of these institutions. And non-compliance will also bring to certain consequences. So accordingly, the analysis of the legislation should not be limited by the description or listing some articles in the labor code, some decrees, resolutions of the Cabinet of Ministers, for example, or other bylaws registered with the Ministry of Justice. We also need to go deeper and to look at how, in practice, these mandatory provisions are applied, especially provisions in the documents with a higher legal power. And once we identify these documents applied in practice, we need to understand what are the internal practices, how they are regulated, what are the criteria in terms of the quality, the competence of the staff, of the personnel. For example, when we hire a person, is it enough to understand that potential candidate should have just a higher education with no specialization? Or, for example, this requires a highly specialized education. So for the beginners, maybe we understand when the work is not that complicated, we may hire those who don't have extensive experience, who just graduated from the universities, for example. The higher educational diploma may be enough, but if we speak about a more complicated, sophisticated job, then the criteria should be more strict and available to the candidates beforehand, so they should have this information about certain criteria. That's why information campaigns, they should be arranged in a way so a bigger potential candidates would be covered, a bigger number would be covered. And what else is important here? The documents, the regulatory acts, do they provide this criteria which are approved by the management of the institution beforehand, and not vice versa, when we have a very good person we trust and we draft the description of the duties and functions judging by this person? No, this should be regulated at the level of the regulatory acts. And if we look at the 1.6 indicator, speaking about the basic conditions following which we need to organize the recruitment, then 1.7 is an indicator which focuses on how in practice it is implemented. So if these procedures, recruitment procedures, if they are in place, do the potential candidates know about this procedure? Do they have a chance to receive information about the conditions and requirements, how a certain person should be hired to a certain position? Only then people will have a chance to shape an opinion whether the sequence of procedures were met. And if they understand that there is a deviation from the practices and procedures which are enshrined in the regulatory acts, these people will be able to protect their rights and interests. And if their concerns were legit, then they would be able to get this position, for example, if they are more qualified. That is why we need to look at these issues in the context of the compliance. Sorry, to address the complaints which could be filed. So that is why we need to involve the people who are interested in making sure that all of the rules are followed. And naturally, in these cases, the stakeholders would be the competitors. If we ensure that the competitors, those who want to get the same position, if they have the right to know the procedure and to monitor the process, we will ensure the recruitment practices based on merits. So 1.7, the indicator focuses on how the public sector is in compliance with the recruitment procedures and practices and the relevant requirements. And this should cover the entire process, starting from the hiring and to retiring, for example. All of the stages, they could be subject to corruption. That is why generally knowing the rights helps significantly to improve the quality of public service, because in such cases we shape the team based on the unbiased criteria and competences. I guess we can continue with the other indicators. Ms. Alma, over to you.
Thank you very much. We have finally two indicators that we called indicators on the de facto, or indicators of response. And this is, we have the one that is connected with the number of appointments that were reverted due to irregularities in the hiring process. This is a formula to understand the proportion, again, in a calendar year. It's connected with all the information that we previously learned from the existence of this system of hiring based on merit. So this basically is to monitor the proportion of appointments that were made without following the standard process that should be followed. So it can be connected with the fact that the candidates maybe did not present the required paperwork, or maybe the candidates did not have all the qualifications that were required, and yet they were hired. Maybe if the period of advertisement was not followed, then that can also be considered as not following the standard process. Maybe during the recruitment process, there was a step that was skipped, or maybe not considered. So the idea is to monitor this. And again, not an easy indicator to have. There are many considerations. Some, for example, in the challenges there that we see that maybe it's not easy to monitor when these irregularities are happening. Maybe the records are not robust enough to actually be able or to spot these irregularities in the process, but a very good indicators to show if there is really proper oversight in the HR, in the human resources processes. And the last one is also connected to the complaints. So this is the number of complaints to existing appeal mechanisms regarding the recruitment process in the last 12 months. So very connected to the previous one as well. And basically, I think we can move on to the next one. I think we can sum up on all these indicators and what kind of insights we can get from them. If we look at all the indicators, the 9 indicators, if we're lucky enough to have good HR systems to actually, and we have the mechanisms in place to monitor all of them, maybe we can see that if there is a high proportion of recruitments that are openly advertised, that are competitive, that are transparent, if our figures shows that we have a high proportion of recruitments following all these criteria. And then if we look at all those indicators connected to the mechanisms for complaints, if we see that those have, let's say, low numbers, but we know that there are good mechanisms, then we can show that there is actually public hiring based on merit. We can see that, there are systems in place to actually prevent corruption in the recruitment of public officials. But if we see the opposite, of course, then we can see that there are weaknesses in the process, and the risk of corruption in recruiting in the public sector is very high. So the recommendation is to ideally have most of these indicators there to be able to show the progress in promoting public recruitment based on merit. And with this, I think we can finish this topic. Asad, over to you. I see questions in the chat. I don't know if you want to address them before we move on to the next topic.
Thank you, Ms. Salome. The majority of questions, they related to the technical issues, getting the access to the presentation, certificates, and etc. And also the language. Those who joined us for the first time, please take into account that we are arranging these webinars for the countries from the region, and we are speaking about the statistical framework on measuring the corruption. This is the first time when we arrange these webinars, and we are actually pioneering this practice. So hopefully the webinar will be uploaded on YouTube, will be viewed, and we need the several languages. For example, we use Russian and English currently, and we are testing out this format, and maybe in future we will be able to improve not only the teaching methods, or we will contribute in another way. I guess, Salma, we need to continue with the next topic.
Very good. So let's go to judiciary in the integrity in the judiciary. I don't think we need to introduce the topic, because I think Oliver gave a very good introduction already. So I think we can move on to the actual table with the indicators. For this topic, we have 12 indicators, very ambitious indeed. But the next slide, please. So everybody can actually see them. I think we can move on to the next one already. Yes. So in this one, you can see the 12 indicators. Again, it's a combination of all the indicators, direct, indirect, perception, risk, response, following the same logic that with other indicators. In these indicators, most of them are actually simpler than in other cases. We can see that in the first one, it's B2.1. This is about ethics. And this is to monitor the number or admonishments for magistrates on ethical grounds in the past 12 months. The idea is to understand what are the ethical breaches and what is the responsiveness of the system in terms of discipline. And if this number is high, then we can show that there are some issues there. But also, if the number is very low, maybe there is an issue of maybe under-reporting, or maybe also high integrity in the system. So this is one of these indicators that is actually a bit tricky to monitor, but yet it's a good indication of efforts in the judiciary to actually try to understand what is happening in terms of ethics. Then we have a second indicator that is the number of successful motions, again, a judge refusal to recuse from a case in the last 12 months. And what this indicator is about is basically to see if there are checks on impartiality for a judge in the system. And if there is any way to actually address any perceived or bias or actual bias in the way that this judge is going to act when working in a case. Then we have those indicators that are more difficult, as we have seen from other topics, the ones that are connected to perception. These are or should come from surveys, and instead of having surveys in the judiciary, these are actually indicators that should be included in surveys to population, because these are actually to understand the perception of the society in relation to the judiciary. And as you can see in this slide, we have two indicators about perception. So the first one is the perception of the judiciary specifically, and the second indicator is about the perception of corruption in prosecution offices. These are challenging indicators because not everybody understands clearly what is the difference between the judiciary and the prosecution offices. But it's a good indication anyway for when actually trying to apply these surveys to collect this information. Is also good to actually help those that are being interviewed to understand what is the difference between the judiciary and the general prosecution offices. Then we have 3 indicators under constraints. We have one that is connected to transparency, and in particular, the proportion of court proceedings that are public. So this is again a proportion, so we use a formula to see how many of these ones are actually public. This indicator faces specific challenges, as sometimes court schedules are not necessarily public. And in many cases, records are not available, but sometimes if they are available, they might not be complete because of privacy issues. So this is really a challenge in terms of openness for the judiciary. Then, and I see you're moving forward into the presentation, which is fine. We can share it, but I wanted to give a general overview. The other indicator number B.2.6 is about randomizations. So this is to understand what is the percentage of cases that were randomly assigned in the past 12 months. And this is also to avoid allocating cases in discretionary way. So by monitoring this indicator, we can understand if this assignment is fair and impartial. So very good indicator as well to see if there are mechanisms in place to keep impartiality in place. Then we have another indicator, and actually Oliver was already sharing with us some of the rationality of promoting judicial integrity, which comes from training, from educating all of those working in the judiciary, understanding about ethics and integrity specifically in this sector. So as I explained in previous webinars, the countries, when we were doing the consultation for building this statistical framework for these many of the indicators, many countries pushed for including indicators connected to training. So this is one of these indicators that were kept. So in this one, the idea is to understand the percentage of judges and prosecutors that received trained on ethics in the last 12 months in relation to the total number of judges and prosecutors. Of course, it's good to know how many or what is the percentage of officials that were trained. But this indicator really does not tell us a lot about the actual effect of this training on the behavior of the people working in the judiciary. But it shows the willingness to have at least everybody, ideally 100% of all these officers working in this sector participating in training related to integrity and ethics. And then I think we have the indicator on the juror. So over to you, Asad, to review the existence of integrity in the judiciary, formally speaking.
Thank you. I guess this indicator on the integrity, judiciary integrity, is the most ensured in terms of the number of the indicators. But at the same time, there is one indicator to evaluate the de jure aspect. But at least it's a very important aspect because it focuses on the most painful part, the transparency of the judiciary, to understand how the system works in terms of the revealed problems. Of course, we understand that there is no ideal system, and we cannot say that absolutely everyone work as honestly, fairly as they are supposed to. So if the problems are not identified, this is also an indication of the problem. If the problems are identified, but none of the measures are taken to address them, it's also an issue. And if we dive deeper, if there are problems which are demonstrated to the public are not that deep, then it's another issue. So we need to analyze the legislation to understand to what extent we strictly define the requirements to disclose the judiciary system activities to avoid any systemic harm. And we have a number of questions we need to think about, at least to try to cover them within the assessment of the situation. Of course, what are the documents and what is the level which imposes the requirement to submit the reporting, or when we go to the level of the certain district or the court, is there any internal policy on the public scrutiny? If yes, then what are the requirements to disclose information? How the process to collect, summarize, and publish the data is organized in terms of the gaps which are revealed throughout the analysis, for example. Also, finally, we can say that we need to understand, are there any requirements on the minimum content of the report? For example, the structure of the report, the structure of the indicators which should be covered, because these are already the minimum standards, and following the standards will ensure the minimum level of quality in terms of the disclosure of information. According to the regulatory framework should ensure the quality of the judiciary. And we always need to pay attention to the following: how, to what extent we regulate all of the stages of the reporting and ensuring the quality. The certain organizations of the certain level, do they take their public scrutiny responsibilities seriously or not? I guess this is the end of the B28 indicator. Next one, Salome, please.
Thank you, Asad. We can move to the last 4 indicators. These are on the response, and these are de facto or implementation indicators. So we have this one that is ethical and integrity related dismissal. This is the proportion of judges or prosecutors that were dismissed on the grounds of ethics and integrity breaches. So this indicator actually in combination with the next ones, we can see the next slide, please. In this slide, we included the 3 indicators that we have seen in other topics before. So this is investigations, prosecutions, and convictions, but in this case is of judges and prosecutors because of corruption. So if we see all these 4 indicators, first of all, the ones that were dismissed on ethical grounds and those that are under investigations, prosecutions, and convictions, we can see them, let's say, together in an integrated way. If we have all of them, we can actually monitor the efforts by the judiciary to have good oversight, to have good systems in place to actually monitor breaches of ethics and integrity. And if we see the trends, we can actually understand if there is a real, let's say, willingness to pursue corruption in the judiciary. So yeah, I think this is basically, I don't know, yeah, I think we are in the last one. These are just the insights, what we can get if we have all these data together. And I didn't go into the disaggregation, but as you saw in some of the indicators, we can actually have disaggregated data. This is a recommendation that we do in the statistical framework. To include the gender perspective, to actually understand if there are any disparities between men and women that required efforts to maybe bring more women into the judiciary, and to actually also monitor if having more women as judges or as prosecutors have any impact. I mean, we, at least from the research perspective, would be very happy to actually see if the trends are different, if we see this disaggregation by gender. So yeah, maybe to recommend that the utility of having all these indicators to have a comprehensive overview of the efforts of promoting independence and integrity in the judiciary, and to actually foster transparency and accountability by monitoring the trends of these indicators. And yeah, I think I will stop here because I think we have one more topic to go. And I don't know how you want to go about this, Asad. If we should go to the next topic, or if we would stop here and take questions.
Yes, actually, we have a question. We will take this question before we move to another indicator. Is there any indicator to evaluate the quality of training on ethics, integrity of judges? What would you say here?
We don't have an indicator in this framework for sure to do that. This is one of the challenges that we always have for training, and that's why when we were doing the consultations, we were pushing back to include training indicators, because countries wanted to include number of trainings provided. And in this case, as you saw, we moved from number of trainings provided to the proportion of officials that were trained in a specific sector. But indeed, our ambition would be to move to the next level. Usually, instead of, I mean, there are many efforts that you can do really to monitor the effectiveness of training. The usual is to monitor the level of understanding and knowledge of a specific concepts. And in those cases, what we typically do is to apply a pre-test and a post-test. That would be the basic. So in the pre-test, we basically ask the trainees to explain the concepts, to explain the implications of these concepts, maybe to give us scenarios to test this knowledge and understanding. And then you do the training, you conduct the training, and then you apply a post-training test in which we can actually, let's say, prove that the concepts are clear, and most importantly, that the expected behavior is now clear for everybody that received this training. I guess having a pre-test and a post-test, it's the minimal that you can have to actually understand if the training was very good. And there is an effective. But there, of course, there is another level that it's more connected to the behavior. But I guess, yeah, for that, you need to actually come back. Well, first of all, you should monitor some of the indicators that we were discussing before. Because, for example, remember that we saw this indicator on the proportion of judges and prosecutors that were dismissed on the grounds of ethics and integrity. If we can actually see that some of those that received training on integrity and independence and ethics were actually dismissed later on, then we can see that the training was not effective. But yeah, that's kind of the next level, and that would be the ideal scenario. And that's why it's important to have really all this data about the training itself, the proportion of those that receive the training in relation to the total number of officials in the institutions, and then those that could be dismissed, or those that were dismissed. And if the ones that were dismissed receive this training, then we can understand that the training is not being effective enough. But again, there are many factors, but we can perhaps suggest this kind of approach in relation to training, because indeed, the number of trainings are not really telling us much about whether or not the training is actually generating the expected change in behavior. Over to you, Asad.
Indeed, training and education as a system, it's another whole sector, which is quite independent. So within the corruption assessment indicators, I guess we would not be able to include this physically. I guess it would be not possible to apply it. So the quality of education, I guess this should be covered by those who are organizing, providing training, but our task is to focus on slightly different aspects. But in any ways, I guess we just need to keep in mind these aspects, because it helps with understanding the entire situation. I guess we need to move forward. So the basic issue on the conflict of interest was covered in the beginning, so we can move to the indicators.
Very good. So we have 7 indicators under these preventive measures of conflict of interest. And actually, we can stay in this slide because we don't have much time left, but we can actually have just a very quick overview of the indicators here. So the first one is the number of detected conflicts of interest that were not declared in the last 12 months. This is a direct measure. Then we have indicators that are considered constraints. So in this one, we have the existence of an asset and conflict of interest disclosure regime. Then we have the control bodies to monitor and manage a conflict of interest disclosures. Then we have employment cooling off periods of public officials in place. Then we have to the jury indicators. And finally, the percentage of officials that were sanctioned because they did not disclose their conflicts of interest in the previous years. We can go very quickly. So in the first one, I think it's pretty straightforward. We can move on to the next slide now. The number of detected conflicts of interests that were not declared by public officials is pretty straightforward, but actually it's a bit difficult to detect those conflicts of interests that were not declared, because usually this only happens when someone is actually looking very carefully at the conflict of interests declarations. We see this usually when it's already too late and when there is a scandal, and actually is not the institutions, an institution the one disclosing this kind of information, but rather this is a result of maybe an investigation by investigative journalism. So very good indicator, but a bit challenging for the institutions to actually have this indicator in place. You can see from the slide there the requirements and the challenges of this indicator, but I won't stop in those because of the sake of time. Then we move to the next ones that are also kind of binary. This is just to have the systems in place for actually the declaration of assets and conflict of interests, and to have a good, solid, well-equipped, well-resourced body, oversight body, to monitor and manage the disclosures of public of interests. And I have to say, now with all the technology that we have in place, this is one of those areas in which we can actually apply, let's say, machine learning and artificial intelligence to connect different databases to actually discover this lack of reporting of conflict of interest or even potential conflict of interest. So, but for this, we would need to really have robust databases of public officials. It's connections maybe with officers in other institutions or other sectors within government. Yeah, I think for this one, it's all about having good systems in place and procedures. So the challenge is not only to have the system in place, but also to have the proper equipment to monitor these conflicts of interest or perceived conflicts of interests. Now, the next indicator is actually an interesting one, but also challenging to implement, because this is about setting up a period for those leaving public sector and stopping them to work for a certain period of time in the private sector, because they might have an advantages that can actually that they can use for their benefit or for the benefit of a sector of the company that decided to hire them. So the challenge is not only to have these periods of cooling off established and well-defined, but there's also the additional challenges of having the system in place to actually monitor the compliance of this indicator. So how can we, or can the government monitor how can the public sector and the public sector institutions monitor if their officials are being hired by private sector after leaving their jobs in the public sector. So is it really a mechanism in place for private companies to report on this. And there's already a challenge. I mean, if the companies can benefit from hiring public officials that have advantageous information, then they might not necessarily be willing to report this to the public sector. So this is one of these very challenging indicators, but in some countries, these rules exist. They are in place. There are restrictions. Private companies cannot hire public officials for a certain period of time. And usually it's many years, actually, 5 to 10 years, because of course, after that period of time, maybe the information that they have might not be as important or valuable for private companies. So these are these indicators, and I think we have two de jure indicators. So for these ones, over to you, Asad.
Thank you, Salama. We will try to be brief. We have only 4 minutes left. So the basic understanding of the conflict of interest, we have this basic understanding, we know how to measure them, but we need to focus on how to regulate all of these aspects, at least 3 dimensions, 3 levels we need to cover within the description of the legislation. Regulatory acts in place, and we speak not only about the laws but also internal organizational practices, policies, and documents, because they may have a wider description of the conflict of interest related specifically to the activities of this organization or an institution. Some of them, they have conflict of interest in terms of the business process. What are the procedures which are regulated by the legislation, the types of the conflict of interest, the situation when there should be the disclosure of the possible conflict of interest. This may be related to the participation of the person in procurement procedures when the person knows, for example, that one of the bidders partially, for example, is owned by the relatives of this person or friends. This also should be actually indicated in the legislation. So the traditions of drafting the legislation are different in all of the countries, but generally we need to take into account what is happening in the country. And of course, we need to understand, are there any sanctions for the deliberate non-disclosure of information about the conflict of interest? And finally, B3.6 indicator, information about the regulation of the lobbying. For our region, this is a quite unique phenomenon, because in our understanding, I guess it will be perceived as non-integral behavior, but looking at the situation broadly, we have a lot of issues on the need to support the national producers, for example, of any kind of production. Doesn't matter. We have the sector-related agencies or associations who are interested in getting more preferences, for example, in terms of the export and import activities or preferential taxes in comparison to other business entities. And naturally, this issue may be considered as one of the types of lobbying the interest of certain groups of people. And if in some countries, for example, there is a direct description of the lobbying and there is nothing in another country, for example, or sometimes it's related to the ethical norms, breaches, but we need to understand that there could be various situations and they may appear due to the objective reasons. But we need to distinguish between these cases when sometimes this is done deliberately. So the legislation should allow us to adequately regulate the activities. And here we are speaking about the same scheme, what documents are regulating such kind of scenarios, what are the requirements on the disclosure, the mechanisms to control and supervise the sanctions, and access to information on lobbying for the public scrutiny. It's also very important because very often there is an announcement of the new job opportunities, but we cannot look at the practical impact, what jobs were created, how it supported the economy, what was the burden to the other sectors of economy or other groups of society. It is all related to the reporting within the lobbying. I guess these are all of the indicators related to the de jure aspect. Handing over to Salome.
Thank you, Asad. This is the last indicator, and this is about the percentage of public officials that were sanctioned for not disclosing conflicts of interest in the previous year. So maybe just to summarize, because I think we run out of time, the combination of these indicators is very interesting because it shows strong efforts on preventing conflict of interests. The challenge is to have proper disclosures regimes in place, but having these regimes set up shows a huge commitment to accountability and transparency. I think in combination, at the end of the day, monitoring conflict of interest helps to ensure that the government is preventing, monitoring, and sanctioning any potential and real conflict of interest. And it's trying really to ensure that the public officials are working to serve the public and not to serve themselves. So basically, while the challenge is in setting up the mechanism in place and the monitoring and then disclosing also, the issue is that these indicators also show a willingness to promote a culture of accountability in the public sector, and the importance of actually for publicly reporting the conflicts of interest. It's really connected to the highest standards of ethics and integrity. So the recommendation again is to, as much as possible, have this information available, transform it into indicators, and ideally disclose it publicly so everybody can actually appreciate the commitment of the public sector to ensure that its officials are not in any conflict when performing their functions. So yeah, I think we can leave it here, Asad. And thank you for this session. And I think we will have another session in 2 weeks' time to actually follow the logic of the statistical framework, because I think we skipped some topics. So I think next time we're going to talk about public procurement and public finance, correct?
Yes, that's right. We'll speak about other issues related to the prevention, and indeed, we will continue to work together. Thank you very much, very colleagues, for staying with us. We have a record number of the participants. I would like to thank our interpreter who was interpreting alone for 1.5 hours and speaking about the specific terminology. Thank you, colleagues. This is the end of the webinar. Please, if needed, please let us know, send us emails. We are always accessible. See you next time. We will start with the discussions of the practical issues. Thank you very much, everyone. See you next time. Thank you. Bye-bye.